statute that has a list of everything except for persons with disabilities, and this is all 659A. So what the 659A shit. Okay, so under 400, it says what a public accommodation is, and I'll get back to that in a second. But under 403, if you violate that, then that's wrong, and it says so. Okay, but that list in 403 that says that it's wrong to violate the public accommodation specifically doesn't include persons with disabilities. To find the person with disabilities protection, you got to go over to 142, and then you got to go to section 4 under that. So 659A.1424 prohibits discrimination by places of public accommodation, and then it continues as defined in 400. So then you go to 400, right? Which it can be busted for violating it under 403, which is kind of right next door, right? But no, if you're a person with a disability, you got to go find your protection under 142, which in 142, subsection 4, about public accommodations specifically says as defined in 400 in the same sentence. You know that sentence includes 400.
Hey, Barry, we're live. I'm just letting you know we went live at 1 minute and 40 seconds ago. Just because you're such an invariable trove of legal researching information, there's no way I could absorb it all in one listen. Like, I immediately want to go back and listen, and then certain things dawn on me. And we have fans. Some people really like what you have to offer. I view you as like a legal scholar, like kind of like a jailhouse lawyer, self-trained innovator of law you're good at the research and the analysis, and it's hard for the low attention span generation to like wrap their head around what you do. I really struggle. I think you really challenge me. You're like 20 years older than me, and you're really smart.
Yeah. Okay, so here's the how to find disability discrimination protection in Oregon Revised Statute 659A.
659A. Right.
Okay, unlike other chapters of law, they had to expand the numbering system to jam in a new one. So instead of having 659 be all by itself, there's actually, who cares if there's a 659? I'm talking about 659A. Different address in the chapters, right? Okay. Well, within that, it has a section that is not about employment discrimination, and it's not about race discrimination, and it's its own little encapsulated section that starts at
yes, the 103. That's where it starts. The unlawful discrimination against persons.
Through where are we at now? 145. I think that's what it is, because that would be housing discrimination.
Right, exactly. And then it moves on to reasonable accommodations relating to pregnancy.
Yeah, and then it goes into employment stuff. Okay, so if you're looking around, okay, so here's where we got to go. So first you go to 659A 142.
Okay.
And that has in it prohibition under subsection 4.
Mm-hmm.
You can't discriminate if you're placed in public accommodation.
Mm-hmm.
Okay. Then you go to, or it says right in the sentence, if you're reading it, it says public accommodation that's defined in statutory language over there in section 400 in that same chapter.
Mm-hmm.
So you go to 69A.400, and it says what a public accommodation is.
Oh, okay. Wait. Okay. Yeah, 400. He's saying 59A, 400.
Yeah, and then you go to 400.
Ah, you're right. Oh, it goes way down. Okay, this is huge.
Okay, now everything you're seeing in 400 is in that sentence because it says so in 142.
Ah, okay. Access to public accommodations, unlawful. Is this better than the ADA in a way?
Yeah, no, because that's the recent case law that I'm telling you. I just found out about in 2019, and I referenced it as a Placey versus Ferguson kind of decision because a person tried to do a good thing for one person and ended up doing a bad thing for a lot of people. Placey fellows that thought he should have better access to the electric rail system, the public rail system in Louisiana. I think it was New Orleans, but it was in Louisiana, and it turned out that the separate but equal decision ended up legalizing racial segregation until the 1950s with Brown versus the Board of Education. It said that it's not illegal to have race segregation in the United States. But the Placey decision was a fellow that just started out doing something that he thought was good, and it ended up creating this law that just opened the gates for Jim Crow and all that because they did it, right? Okay, so anyhow, what happened was this gal files an action that she's allowed to, and then it goes to court, and they say that she can't win because, according to the language in that 142.4 about prohibition, that only applies to people that are customers or patrons.
Yeah.
Because she, under that fact setting, didn't qualify as a customer or a patron, then the accommodations protections didn't apply to her. Although she might be protected by the ADA, she wouldn't be protected by that particular
section. Yeah.
The legislature used the word customer or patron instead of the word individual. So if you can't qualify as a customer or patron, then you don't have that protection. And the difference in my mind is that they what they did in the case is they looked up and it says that a customer is a person that pays, a patron is a person that pays. That's basically what they said. So commerce involved, then that you can't be a patron. If you can't be a patron, then you can't be protected under the public accommodations law that protects you if you are a patron.
Wow.
Okay, so anyhow, the difference in my mind, between a customer and a patron is that a customer can pay or not. You can shop and be a customer, right? But a patron sometimes can pay, sometimes can't pay.
Well, like you could pay once a year and patronize a museum, or you could patronize a church, but are you necessarily putting money in the till?
What about the library?
Yeah, you're a library patron. You could just look at the walls if you want to.
You can't pay at the library.
Wow.
There's no way to be a paying customer at a free library.
Wow.
Right. Okay. So anyhow, somebody in one of my a million. There's 43 named defendants, and some of the named defendants are unknown. So who knows who they are, right? So there's even more. But anyhow, I've got a stack of lawyers that are up against me, and one of them pointed out that you don't have disability discrimination protection according to this particular case, right? But if you go to 400 again and look up it says, what's it say? Regardless if there's, let me regardless if it's commerce, right? Is that what it says?
So in the unlawful, okay, regardless of whether the service is commercial in nature, boom. Oh, that's sweet. That's clause C in 659A 400. Any service to the public that is provided by the public body. Yeah. So the service could be like
the library.
Yeah, or
the police.
Right. I'm thinking like a bell, like an alarm, because that's a service. I don't know.
No.
Anything.
The fire department.
The fire department.
You can't possibly be a patron of the fire department.
Wow.
You can't be a customer of the fire department. You're just a citizen, and you get the services.
Mm-hmm.
And regardless if those services are commercial and they're still considered a public accommodation. That is not allowed to discriminate against persons with disabilities according to 142.
142.
That has in the very sentence of 142 the entire text of 400. You just found it doesn't have to be commercial. So to require somebody to be a customer or patron of a public service that simply has to recognize that the intent of the legislature is to recognize places where you pay and places where it's free, like a school patron.
Yeah.
So I got on Google Scholar and I typed in patron and library,
Mm-hmm.
and I ended up looking up this one case that somehow, because I was jumping around, I ended up getting this quote from a 1951 or something Oregon Supreme Court case, concurring opinion or something or other. It's going off into the weeds. But what it said was about some land on the Ohio River that they wanted to incorporate. I know what it was. It was Estacada. Estacada wanted to do something at some. Estacada was one of the players in the case, right? The city of Estacada, right?
City of
Which then
Estacada.
was not that big of a deal, right? It was getting bigger all the time, right? So anyhow, that's why they wanted to annex or whatever the story was. But the thing of it is, this guy is this judge ends up putting in this 1951 concurring opinion or whatever. He starts referencing this water on the Ohio River that is like below the water line and might be mudflats or something. But it was like they couldn't incorporate that into the school district because no patrons of the school it wouldn't have school kids. It wouldn't be part of the school district. It shouldn't be part of the school district because it's underwater or something. Was the gist of it, right? But the thing of it is, they use the word patron in conjunction with the public school. So I think that what the lawyers are trying to do, because one of them tried to do it on me, is they're trying to say that this case, the 2019 case out of Eugene, that case means that it specifically says so. That if you can't prove you're a customer or patron, there's grounds for summary judgment. You get your case done.
Summary judgment.
Can you find the case in Eugene?
So, the wheelchair lawyer lady case, is that the one you want me to be looking for?
Yeah, did you look at it? Here, it's easy. It's
What?
easy to find.
Okay, how do I look?
It's easy. Go to Google Scholar.
Okay, Google Scholar.
Go to case law.
Okay. Google Scholar. How fun. Case law. Okay. Oregon courts, federal.
Select courts. Yeah. Go Oregon courts.
Oregon courts. Select courts. Okay.
And then type in library and patron.
Okay. Library and patron. Okay. Case law. Library. Patron. Wow. No way. Okay.
Right.
Is it? Whoa. I feel like I didn't refine the search enough.
It's a name versus it's a electric co-op.
Okay, so I feel like, let me go back and remember how my Firefox performed differently than Chrome? I'm using a different browser, but when I'm in the state court select, I just select Oregon, is that right? And that'll refine it quite a lot?
Yeah.
Okay, let's go. Okay, then library patron. Okay, here we go. Oh, there's not much. Okay, is it this?
BLE something?
State v. Davis, Fenimore, Nearing v. Weaver, Fenimore v. Blatchley Lane.
Yeah, that's it.
Okay, cool. Oh, thank you for taking me here. Wow. Oh, excitement.
Statutory interpretation.
Okay.
But where they went around is not addressing the conflict in what they did was they basically interpreted that the customer and patron means the same thing.
Oh, hey, hold up. I got a call. Hi, Heather. Hey, hold on a second. Let me get off the other line. Hey, Barry, I actually have to take this call. I can call you right back. Okay, Barry? Okay, bye-bye.
Yeah. Bye-bye.
Are you there?